Many people don't know this, but the 1986 movie Top Gun was inspired by an article written by a journalist named Ehud Yonay called Top Guns, which was published in California Magazine in 1983. The article was about the real U.S. Navy fighter weapons school, which is also called Top Gun. The article talked about the experiences of two Navy officers in the fighter weapons school who were training to be part of a fighter pilot crew. It also talked about the Navy's use of some of the jargon that we know and love from the Top Gun films, such as bogey to mean an enemy plane and hops to mean air combat maneuvers. As most of you will know, Paramount Pictures released a huge hit sequel to Top Gun in 2022 called Top Gun Maverick. Yonays' widow and son are now suing Paramount, claiming that Top Gun Maverick infringed Ehud Yonay's copyright because it allegedly copied content in the movie from the 1983 article. This case illustrates some of the key principles of U.S. copyright law, which are very useful for filmmakers to understand, and so I figured it would be worthy of discussion here on the old channel. But before we get into that, a few disclaimers, because of course we attorneys can't resist disclaiming things. First, this is not legal advice, because if I were to be giving you legal advice, I would need to understand your specific situation and needs, and right now I'm just a random lawyer talking to you on the internet. Second, I'm going to be talking about matters of U.S. law. So if you're making a film or your production company is located outside the United States, then some of the legal concepts that I talk about in this video might not apply to you. And finally, if you found this content valuable or fun, please like this video and subscribe to this channel so that I can keep giving you this kind of high-quality educational content in the future. Anyway, back to Ehud Yonay's 1983 article called Top Guns. Yonay signed a contract assigning the motion picture rights to Paramount, meaning he gave Paramount the right to make a film based on the article. The 1986 Top Gun movie, in fact, acknowledged that it was inspired by Yonay's article in the credits. Yonay died in 2012, and his widow and son, who I'll refer to as the Yonays, inherited his rights under the license agreement with Paramount. They terminated their contract with Paramount in 2020. After Paramount released Top Gun Maverick in 2022, the Yonays sued Paramount, claiming that Top Gun Maverick infringed their copyright. The lawsuit is still going on as of the date of this video. Just recently, the Yonays and Paramount both filed what are called motions for summary judgment, meaning that they both essentially claim that the case should be resolved in their favor without the need for a trial. Let's get into the arguments that the parties make in these dueling summary judgment motions, because like I said, I think they do a great job of illustrating the copyright issues that often come up at actually a lot of different stages of the indie filmmaking process. I won't claim to address every single argument that the parties make, because then I'd be making a video that lasted, several hours, and I doubt that people want to watch that. I mean, after all, if you wanted to take a comprehensive class on copyright, you would go to law school, right? But I'll do my best to hit the high points. To start with, for the Yonays to show that Top Gun Maverick infringed the copyright in the 1983 article, they would have to prove that the movie is substantially similar to the article. Let's unpack what that means, because it's a legal concept that might sound simple, but it definitely is not. The first point to make is that it wouldn't be enough for the Yonays to simply show that Top Gun Maverick is about the Navy's Top Gun program, just like the Yonay article. All that would mean is that the movie and the article are based on the same story idea. But copyright law doesn't protect mere ideas. Instead, you can only copyright what's called an expression of an idea. What does that mean in practice? For example, let's say that I come up with an idea for a movie script about teenage vampires from Mars, and I send my friend an email saying, I think this would be a really good idea, and then he goes out and writes a successful screenplay that's based on that story idea. I can't sue him for copyright infringement under those circumstances, because I can't copyright the mere concept or idea of teenage vampires from Mars. But if I write an actual screenplay about teenage vampires from Mars, my script is an expression of that story idea, and so it is protected by copyright law. If my so-called friend in this example writes his own script and he borrows dialogue or characters or structure from my script, he can infringe my copyright. On a similar note, copyright law doesn't allow you to copyright facts. Yonay's article is nonfiction. In other words, Yonay didn't make up the Top Gun Navy program. It's an actual thing that exists in the world. In fact, Paramount extensively worked with the U.S. Navy to make sure that Top Gun Maverick's description of the Top Gun program was accurate. If the fact that Yonay wrote an article about the Navy Top Gun school meant that no one could produce any kind of creative work about the Top Gun school without Yonay's permission, that would effectively give Yonay a monopoly over all creative works about a historical subject or a historical set of facts, which copyright law is not intended to do, and in fact would be a terrible result. For example, if I write a book about World War II, we wouldn't want the Copyright Act to allow me to prevent anyone else from writing a book about World War II, because that would be very stifling to creative expression and to historical research. So to sum up what we've talked about so far, for the Yonays to show that Paramount infringed their copyright, It's not enough for them to show that Top Gun Maverick and Ehud Yonay's article are both about the Top Gun Navy School. The Yonays instead have to show that specific dialogue, characters, plot, or themes, or other elements of the movie and the article are substantially similar. Now, do the Yonays succeed in doing that? Ultimately, the judge is going to make that decision, not me. But based on the documents that I've read, the public documents from the court case, I think that the Yonays are going to have a tough time proving copyright infringement here. For starters, the 1983 Yonay article doesn't really contain dialogue per se, because it's a nonfiction article and not a movie screenplay. Nor does Top Gun Maverick directly quote from Yonay's article. So, unlike a situation where a screenwriter claims that a movie infringed the copyright in his script by ripping off dialogue from him, the Yonays can't really claim that Top Gun Maverick copied or came close to copying the actual text of the 1983 article. So we have to look at other types of similarities, like the characters and the plot of the stories told in the movie and in the article. What kind of similarities do the Yonays point to in that sense? Let's look at some examples. Again, this is not going to be an exhaustive list to avoid this video taking several hours. First, the Yonays say that the training exercises the pilots do in the 1983 article and in Top Gun Maverick are similar. But, as Paramount points out, the reason for that is that both Yonay's article and Top Gun Maverick describe actual training exercises used by the Navy. And for the reasons I discussed, Yonay doesn't hold a copyright in the training used in the real-life Navy Top Gun program. Second, the Yonays say that the Navy fighter pilots described in the 1983 article and in Top Gun Maverick are both sort of macho hotshots who drink and carouse and are competitive with each other. One problem with this argument is that the pilots discussed in the 1983 article are real-life people and not fictional characters. Just as writing a book about World War II wouldn't give me the right under copyright law to prevent anybody else from writing about World War II, you can't use copyright law to prevent other people from writing about a real-life person or creating a character who shares aspects of them or shares their personality. This also illustrates another important point about copyright law. You can't copyright a cliché. Of course, you would expect a fighter pilot in an action film like Top Gun Maverick to have a macho, hotshot personality, because that's the type of personality action movie heroes tend to have. So, what the courts have decided is that one writer's use of a cliched or stock character doesn't give the writer the right, under the Copyright Act, to prevent others from using a cliched or stock character who's similar to that one in their creative works. Now, in the same vein, the Yonays point out that the 1983 article and Top Gun Maverick both talk about a conflict between a hotshot Navy pilot and the top brass. But again, an action hero character who is a maverick, if you will, and a loose cannon and plays by his own rules is a common character type in books and movies and therefore is not copyrightable. The most concrete example of a similarity between the 1983 article and Top Gun Maverick that's cited by the Yonays has to do with Navy officers' clubs. The article mentions that in a Navy officers' club, there's a bell that people ring when someone breaks the club's house rules, and the ringing of the bell signifies that the rule breaker has to buy drinks for everybody in the club. In Top Gun Maverick, there's also an officers' club with a bell that people ring when someone breaks the house rules, with the same consequences. But again, that's not a concept that Yonay's 1983 article created. The custom of having a bell in a Navy club that gets rung when someone breaks the rules exists in real life. In fact, the director of Top Gun Maverick apparently went to an actual Navy officers' club, he broke the house rules, someone rang the bell, and he had to buy drinks for everybody as per this custom. Now, all this discussion might sound a little bit unfair from the perspective of the Yonays. After all, even if the 1983 article is predominantly about historical facts, and you can't copyright historical facts, it was the article that was responsible for inspiring the writers of the 1986 film Top Gun to make that movie, and of course, the sequel wouldn't have existed without the massive success of the 1986 film. But when you think about it, really all that means is that Yonay's article inspired the writers to make the 1986 film Top Gun, and it can't be that this alone means that the writers infringed Yonay's copyright. If just taking inspiration from a creative work like a book or movie amounted to infringing the copyright in that book or movie, basically nobody could make art, because artists are always heavily inspired or influenced by somebody else's work, right? You could also argue from the perspective of the Yonays that, hey, Paramount specifically negotiated a license to base the 1986 film on Yonay's article, and Paramount wouldn't have done that if it believed that Yonay's article consisted only of non-copyrightable historical facts, right? So you could argue that by entering into the license agreement, Paramount basically admitted that a substantial amount of the content in the article was protected by copyright. So as the Yonays themselves say, it's dishonest for Paramount to now turn around and claim that the article is all just a bunch of historical facts that are not subject to copyright. But again, I think this ignores the realities of making films on a scale that Paramount and other major movie studios do. Given the amount of money that's at stake if a studio is found to have infringed somebody's copyright, it's in Paramount's best interests to make sure that it gets a license from anyone who could potentially make a copyright claim, regardless of whether Paramount's lawyers think that that claim ultimately holds water. If Paramount didn't make a habit of doing that, they'd be taking a big risk, because what happens in copyright litigation can be unpredictable. So Paramount really did the right thing from a risk management standpoint by making sure that it signed a license agreement with Yonay, and we shouldn't interpret the fact that it signed that agreement as an admission by Paramount that the contents of the 1983 article are copyrightable, or that the original Top Gun movie, or certainly that Top Gun Maverick, used copyrighted material from that article. So to sum up, I think that Paramount has the better of the copyright argument here. Most of the similarities that the Yonays point to between the 1983 article and Top Gun Maverick exist because both the film and the article are based on real-life facts about the Navy Top Gun school, which both Ehud Yonay and the makers of Top Gun Maverick extensively researched. Because you can't copyright historical facts, Paramount didn't infringe the Yonays' copyright by incorporating those facts into the movie. But the judge in this case has yet to rule on the summary judgment motions. In fact, they were just filed, so we'll see what happens. So what are the key copyright law concepts that this case helps us understand? First, like I said, you can't copyright a story idea. The mere idea of a movie about teenage vampires from Mars is not copyrightable. But an expression of that idea, which in this case would be a script that uses that idea for a story, would be protected by copyright. Second, you can't copyright historical facts. In other words, you might say you can't copyright reality. The mere fact that Yonay wrote his article about the Navy Top Gun school doesn't mean that Yonay now has the exclusive right, under the U.S. Copyright Act, to prevent anybody else from writing about that subject. Third, you can't copyright cliches or common story tropes. If I write a script about an action hero who's kind of a man's man and he's square-jawed and stoic and doesn't get along with authority figures, that's such a common trope in Hollywood that I can't be sued for copyright infringement for using it, even if it does resemble a lot of Clint Eastwood characters. Fourth, if you think that there's any risk at all that you could be sued based on your movie for infringing somebody's copyright, the best practice is almost always to sign a license agreement with anyone who you think could potentially make that kind of claim. And that's true even if you think that a court would disagree with their copyright claim if they actually brought a lawsuit against you. As you can probably tell from this video, copyright infringement litigation is unpredictable. There are a lot of subjective-looking judgment calls that go into deciding whether copyright infringement has occurred. And so you want to do your best to protect yourself from any potential liability. Anyway, I hope this was helpful to you in understanding the copyright issues that are raised by the dispute over Top Gun Maverick. If you have any questions I didn't answer in this video, please put them in the comments section. And thank you for watching.